Hello, I'm Richard Wenner, and in this video, I'll explain what to do if you find yourself named as an executor in a will. The executor is the person who looks after the affairs of the deceased after they've died. He or she literally stands in the shoes of the deceased. The executor plays a critical role. Serving in this capacity can be a way to honor a good friend or a loved one by helping to wrap up their affairs and ensuring their wishes are fulfilled. A beneficiary can also be named as executor. The advantage is that such an individual will take extra care to ensure that the estate is managed and wound up as efficiently as possible. Once they accept their appointment, the executor is personally responsible for the management of the deceased's affairs, including the payment of all estate debt and taxes. For example, if the estate is distributed before the estate debt or taxes are paid in full, the executor will be personally responsible for making up the shortfall. Being named as an executor does not mean that you have to accept. Careful thought should be given before accepting the appointment. I'd recommend that you first discuss the matter with a lawyer before you make your decision. It should also be noted that once you get involved and start making decisions with regard to the administration of the deceased estate, you are deemed to have accepted the appointment, and once in, it is not easy to get out. What does an executor do? The duties of the executor are threefold. First, transfer the deceased's assets into the executor's name in trust. 2, to pay all estate debt, including taxes. 3, to distribute the estate in accordance with the terms of the deceased's will. What is probate, and when do you need it? Probate is a court order confirming the validity of the will. The executor will need to obtain probate if the deceased owned real estate, bank accounts, or other such investments that are administered or registered with a bank, investment company, or land registry. None of these institutions will release assets under their control until they're satisfied that the will is the final will of the deceased and the executor has legal authority to act. Probate provides that authority. If the deceased owned no assets in his or her name, there may be no need for probate. For example, if the deceased's assets were all jointly owned with a spouse, then on death, those assets would have automatically been transferred to the surviving spouse. There'd be no need for probate. Similarly, if all the deceased owned was cash in his safe or perhaps in his mattress, there'd be no need for probate, as no institution required confirmation of the validity of the will. How do you get probate? The process is a little complex. Here's a very brief summary of what you need to do. Locate the will. How do you do this? Go through the deceased's personal papers and the safety deposit box if there is one. Most lawyers and notaries, after they prepare a will, file a notice with the will's notice registry, which confirms the date of the will and where it can be located. Search the registry for the location of the most recent will. This is simply an available service. Failure to register does not make a will invalid. What if you can find a copy, but not the original? This is not as catastrophic as it once was. The court will accept a copy, provided the executor can provide a reasonable explanation as to how it got lost. Next, send a copy of the will, together with a formal court-mandated notice, to each beneficiary named in the will, and each person who would have been a beneficiary had there been no will. A lawyer can help you determine whom this might include. The law will not allow the application to be submitted to the court until 21 days has passed from the date of the last beneficiary to be served. The application for probate must also include a summary of assets of the deceased and their value as at the date of death. Finally, probate will not be granted until the probate tax has been paid. The tax is calculated on 1.4% of the gross value of the estate of the deceased. How long does the process take? It often takes a while to determine the exact value of the estate. For example, it can take weeks or sometimes months to get responses from each financial institution with which the deceased had accounts. If the deceased owned a privately held company, it may be necessary to obtain a formal valuation of the company. This can also take time. Once the application is submitted, the probate registry can sometimes take months before processing the application. Dealing with the death of a loved one is hard enough. Dealing with the legalities can be mind-numbing. We're here to help. Feel free to contact me.